Very good afternoon to all our listeners and to all our viewers. Some of you are traveling from work to home, and with all the interesting, intriguing news around our country. Leaving that as it may, I would like us to continue with our program, Root Out Corruption from Namibia. And in it, we are assisted by the Office of the United Nations on Drugs and Crime. It helps us to understand the interventions needed to mitigate the spread, to deter the spread of this cancerous condition, developmental condition, altering condition that is called corruption. And I hope so far we remember what we have been saying all along in terms of understanding what corruption is and conditions under which corruption flourish and conditions under which corruption can be deterred. And as we are now going on and on, we are talking about necessary instruments or tools, if you like, that one can utilize to fix this corruption issue. So I hope we all remember now we have a definition. What is corruption? I hope we all have a definition. The meaning of corruption and the common forms of corruption. We have what we call grand and petty corruption. And please take note, we said there is no global or comprehensive, universal, accepted definition of corruption. And attempts to develop such a definition invariably encounter legal and criminological and, in many countries, even political problems. But nevertheless, you have to find a meaning suitable for your country. And in this case, we spoke about grand and petty corruption. We spoke about active and passive corruption. We spoke about bribery. And as we spoke about bribery, we spoke about types of bribery, namely influence peddling, offering or receiving improper gifts, bribery to avoid liability for taxes or other costs, bribery in support of fraud, and bribery to avoid criminal liability, and bribery in support of unfair competition for the benefit or resources, and private sector bribery, as well as bribery to obtain confidential or inside information. We spoke also about embezzlement, what it is, theft, and fraud. We now have an understanding what those things are, and we also then spoke about extortion, abuse of discretion, favoritism, nepotism, clientelism, and conduct to create exploiting conflicting interests, improper political contributions, and all that. Those are all terms that are very common universally. You go in any country, people will be complaining about bribery, people will be complaining about theft and fraud, embezzlement, abuse of discretion, and unfair competitions, and all type of things. And we have learned the negative impacts of corruption to society, to countries, and we spoke conditions that facilitate corruption, and then we also spoke conditions required to prevent corruption, and we spoke about the need to involve all key stakeholders, as well as the link between money laundering and corruption, as well as constructing anti-corruption strategy that will require integrated approach. And we spoke about common basic elements of anti-corruption strategies and an integrated approach to developing and implementing strategies. We spoke about now the need for development, implementation, adjustment based on assessment and on facts, the need for transparency, the need for non-partisan or multi-partisan approach. Then we need to talk about the inclusiveness, the comprehensiveness, impact-oriented elements and strategies, and the need for flexibility and all that. Having understood those things in general, and this must be the understanding of the nation, we now have an obligation, if you like, to delve into developing an effective and efficient anti-corruption strategy if we have done all of those things. And I have indicated that when we are talking about fighting corruption, corruption must not only be fought from the level of anti-corruption commission or whatever, but we must, as much as we can, to have a bloated sort of approach, and anti-corruption bodies or agencies should only be part of the broader thing. All of us must find a way to fight corruption in our individual lives and in religious institutions and in our private sector, in our public offices. We should be able to develop a strategy within institutions that are aligned with the national strategy to fight corruption. Now, we spoke then about the tools that now, or the keys that are now going to help us. And we spoke a lot last week on this station how we should assess the nature and extent of corruption as tool one, under the assessment of corruption and of institutional capabilities against corruption, especially through tool 2. We shouldn't just jump up and start fighting corruption. We should rather study and assess the extent and the nature, because you have active corruption, you have passive corruption, you have grand corruption, you have petty corruption, you have embezzlement, you have fraud, you have clientelism, you have bribery. What are the nature, or what is the nature of corruption in the locality of Namibia? Because what might be happening in Zimbabwe may not be really what's happening in Namibia. What is common in European countries, maybe UK or wherever, may not be what happens here. So we have to determine what are the common forms of corruption in Namibia. Do we know them? Can we really say, no, the common form of corruption in Namibia is bribes? The common forms of corruption in Namibia are fraud or embezzlement or abuse of discretion or things like that. We should diagnose, if you like. We should be able to say, to pinpoint and say in a very direct way, the common problem when it comes to corruption in Namibia is A and B and C. That is what we have discussed last week. And to what extent? How did it affect our resources? How did it affect us, if you know what I mean? And then from there you move on to tool number 2, in which you discuss what we call assessment of the institutional capacities and response to corruption. What are the institutions that we have? Are they capacitated in terms of tackling, deterring, identifying, and prosecuting corruption? Then, when we have assessed institutional capacities and the response to corruption, then we talk about institutional building. Like now, the anti-corruption agencies, maybe anti-corruption commission in our case, maybe ombudsman, maybe prosecutor general, maybe auditor general, maybe. We need to build those institutions and empower them to make sure those who are guilty of corruption are brought to book. Yes, auditors and audit institutions. And remember, we mentioned already last time that we need not only books of the public to be audited, but we need these books to be made known to the public, and also to know what happens to the reports, what actions have been taken or are to be taken in order to make sure that no repeat in the next report, and so on and so forth. Then we talk about the ombudsman. Then we talk about strengthening judicial institution. And maybe let me start there again from the ombudsman. Okay? Ombudsman is in some countries is called public protector, especially in South Africa. It's equivalent to what is called public protector. Yeah? Generally, this is the office you go to, in our case, to complain when your constitutional rights have been violated by perception or by real. If you think your rights were somehow violated, you can approach the office of the ombudsman to make sure that things were done in the good order, in line with our constitution. Therefore, in many ways, it is also preventing corruption from happening, because it's entitled to protect the public. So here I read, tool number 5 provides an overview of the mandate and functions of the ombudsman, which in most countries generally go beyond corruption cases to include maladministration, attributes to incompetence, to bias, to error or indifference, if you know what I mean. Ombudsman must not only deal with enforcing constitutional discipline and curbing some corrupt activities, especially when it comes to maybe employment, the allocation of land, the allocation of debt, resources and that. But its work must include dealing with issues of maladministration or abnormal administration. What is maladministration? We need to talk about that in the next program, I would guess, because we need to understand each and every word. What is maladministration and why it should be dealt with? Otherwise, it will become a disease, and it may obviously be as well classified as corruption, where people are just doing as they wish. Maladministration. People are doing as they wish. They are not following the policy. They are not following the standards. They are not following the guideline. They do as they wish. They procure as they wish. They follow no procedure at all. It's maladministration. We will talk about it. And then it must also deal with incompetence. It should be the office of the Ombudsman to determine whether there is performance in this public office. If there is incompetence, this person is incompetent to act. This person is incompetent to do the work that is entrusted with him or with her. The Ombudsman must be able to assess the performance maybe of this particular office. Or bias, where people are biased against this in favor of that. The ombudsman must be able to determine why is there a commotion of this nature. Yes, it's truly you were biased here. Maybe you should have done it this way. And error, many mistakes, when error is committed, must be corrected. When a mistake is committed, it must be corrected. And the only person who could help you with that is the ombudsman. Or indifference, where people don't care whether it goes left or it goes right. They don't care. We should care because we must do what is right. We must be known to be doing what is right, and we must be seen to be doing what is right. For instance, and as many complaints will not know or suspect the presence of corruption, the ombudsman can play an important role in determining this and referring such cases to anti-corruption agency or prosecutor for further action. Can you see there is a difference? The ombudsperson does not prosecute, but they can refer the case to the prosecutor general. Can you see? Prosecuting authority, for instance, in our case. Or they can simply send the information to anti-corruption agency, which in our case is anti-corruption commission for further action, including investigation or arrests or prosecution. So there must be a working together between the Anti-Corruption Agency, that's now the Anti-Corruption Commission, the Office of the Ombudsman, and the Office of Prosecutor General. They must be working together, and in many cases, I keep on saying, even in the Office of the the Auditor General in our case must work together so that culprits who are practicing mismanagement or maladministration must be identified, and they must be corrected. Yeah, we cannot just let things like that. Then further advantages of ombudsman structures are their informality, which allow them to be used in relatively minor cases, and their powers to fashion suitable remedy for the complainant. In some countries, ombudsmen have taken more proactive role in studying the efficiency and operational policies of public institutions in an effort to prevent injustices occurring in the first place. I just would like to give an example when it comes to people who feels that their rights or bias or whatever is done against them. In the Namibian context, the state machinery is there to protect all the Namibians, irrespective of what they are, of who they are, of their status, whatever their identity is. In this case, the state machinery has an obligation to protect all the Namibian people. What I have observed, however, is the fact that there is a problem, especially in the traditional authorities, where these upcoming prophetic or charismatic or Pentecostal movements are cropping up, and they are told, we cannot allow you to operate in our village. In the interest of Constitution, fairness and justice for all, nobody has got the right, extra rights outside of the Constitution to prevent anybody from practicing, believing, and manifesting any form of religion in Namibia. And these religions must be practiced in nowhere else but in Namibia. We don't care it is in your village or it is in your traditional jurisdiction, for as long as it is in Namibia. And all my friends, all our colleagues who think they are above the law, they are mistaken when it comes to bias here. Yes, you may have a reason, but these churches and these religious groups, they are actually creating commotions in the village and so on and so forth. The law is clear in Namibia. We don't take law into our own hands. If somebody accuses you falsely, that is called defamation and character assassination, and a person can actually sue whoever. And the court of law has got the jurisdiction over these things, and they may actually tell this person either to stop practicing or to stop defaming others or whatever, for as long as it is not done by the competent court of law. When we are talking about the competent court of law, we are talking about people who have studied the law and they are able to apply the natural principles of what the law is saying. So this bias is not allowed in Namibia. When somebody harms you, whether by false accusation or whatever, there are procedures to be followed. And this person can then be taken to task following the law. So here I am just saying the office of the ombudsman is there to protect the nation, individuals, and therefore it deals with small issues, for instance. And therefore in the Namibian constitution, the ombudsman is there even to facilitate reconciliation, even to make sure there is no disagreement between that person and that person and that person. So now there need to be an independence, a sense of independence. There should be some form of independence when it comes to the office of the ombudsman. The need for broader mandate and jurisdiction to allow the ombudsman to consider complaints that are not within the purview of the forum, such as courts, administrative tribunals, as well as requirement for adequate investigative powers, operational transparency, accessibility, and resources. Also discusses extensively the role of ombudsmen and similar institutions as an element of anti-corruption strategies in the international organization and activities where mandates would focus primarily on areas of external complaint about the functions of the organization itself. The same operational safeguard would apply to ombudsmen in international organizations as those at the national level. The United Nations is made clear it is made clear, has its own internal auditing mechanism. So in other words, we need in each country, and in Namibia in particular, the office of the ombudsman to be independent and to consider complaints, especially that are not immediately found to be within the other forums or the other platforms, such as maybe courts or tribunals, and so far. Maybe the office of the ombudsman must also be accorded an opportunity to have some investigative powers and to determine the transparencies and to determine the accessibility and to determine the resources. So that is the office of the ombudsman in fighting corruption. We know a case in South Africa where the public protectors can bring the case against any leader who is found to be wanting. They will bring the case because they want to protect the public. There must be somebody who sees what the public cannot see. There must be an office that deals as intermediary between the public and whoever. If it is a mistreatment of patients at clinic, if it is unfairness in admission of children in a local school, if it is issues of land allocation, as I have mentioned, especially in the rural areas where it is just a nightmare, whether it is a political issue, obviously political issues can be resolved at that level. I just think an ordinary person who is aggrieved must be able to approach a particular office and tell what is the problem and why do they need a certain protection when it comes to their rights or to their privileges and so on and so forth. So that is the office of the ombudsman. In other words, it can help fight corruption. Now you have the anti-corruption agency. Now you have the ombudsman, the office of a person who is there to listen and to help the public and to help enforce the constitutional principles. Then we move on to tool 6 again, which is to strengthen judicial system. As the senior, most respected and smallest criminal justice institution, the judiciary is relatively accessible to early, small-scale anti-corruption efforts. Moreover, it is at a judicial level that corruption does the greatest harm and where reforms have the greatest potential to improve the situation. Thus, measures directed at judges themselves should generally be implemented as a first step towards strengthening judicial institutions against corruption. A balance must, however, be struck between ensuring the independence of the judiciary and making it accountable. And this is where the problem is. One of the problems people are complaining, especially in this country, is the question whether the judiciary is truly and really independent in terms of taking decisions, in terms of prosecuting, in terms of listening to the submissions by this person or against that person in favor of that person. How independent is the judiciary? And I will not create a narrative around that other than what is indicated there. There must be a balance between the independence of the judiciary, especially in making sure they are adjudicating cases in a proper way, and also they must be accountable. Somebody must be able to say, hey, I have not studied the law, but here, this is not how I should have done so. Why did you do this? Because even if we are not studied the law, we are not judges, we are not what, we still know what is true and what is false, what is fair and what is unfair. We should be able to determine what is light, what is darkness, what is real, what is imaginary. We should be able to know those things. And therefore, we should be able to hold the judiciary accountable. And because they are also to be paid by the state coffers, they should also be accountable to the very same process when it comes to the finances, that we have given you finances, we have been paying you, we have been giving your office this and that. You must now be able to tell us what you have done and what you have used our money for. There must be the balance between the judiciary, the independence of the judiciary, and the making them accountable for their actions. We cannot just say, oh, it is the judiciary who said, so we keep quiet. We should be able to question them. Why did you do this? No, we have done this because of A, because of A. They should be answerable to somebody. And they should not also ask people, who are you? Why are you asking me? We have already decided upon the case. Tell us, how did you come to this conclusion? It is their obligation to be able to explain to us, the lay people, when it comes to that language, why did they come to this conclusion? We have come to this conclusion because of A, B, C, and D. You see? Sometimes we say if the judiciary has closed the case, then the case must be closed. We must not complain, we must not talk about it, and so on and so on. In my view, and in the interests of the United Nations advice, we should be able to hold the judiciary accountable as well for their actions. Because simply they are human beings too, and they can be tempted to make some deliberate mistakes or mere mistakes. So we need to strengthen the judicial institutions in that level. Training in professional competence and integrity, as well as the development or review of the judicial code of conduct and informal discussion on ethical, substantive, procedural issues, all form part of the process of strengthening the judiciary. Why are we talking about the judiciary? Because when crime is committed, obviously the person brings the case against the lawbreaker, if you like. Maybe the police person will arrest this person. And this person who is arrested to alleged to have committed crime will be taken to court within a particular period of time as prescribed in the Constitution. You must appear before the court of law within this period of time. Now this person comes to the judiciary. That's how the judiciary comes in. So we talk about preventing corruption, but we are talking also when corruption has been committed. So when it has been committed or alleged to have been committed or perceived to have been committed, there must be all these processes. Maybe arrests, maybe investigations, maybe bringing the case against this person, and the court must listen and hear the case. Then you need people with professional competence in the judiciary system. We don't need half-cooked judges. We also need people with integrity to deal with these issues. We need also the code of conduct must be updated all the time for the judicial fraternity. Then there must be informal and even formal discussions on ethics or ethical or substantive and procedural issues. All form part of process of strengthening the judiciary. Ethics, what is acceptable, what is ethically good, what is morally acceptable. Can we receive? Can the judge be called before the judgment tomorrow? Can the judge be called behind the closed door by certain politician and tell them what to say tomorrow? Is that ethically? Is that ethical? Is that moral? Is that morally right? Is that moral? Is that morally right? I don't think it is. And therefore, on that level, judges need to be updated all the time, to be refreshed all the time, so that they may not lose the integrity of being judges. Just as you have nurses, just as you have doctors, just as you have all health workers, they have always to be refreshed and sensitized on ethical considerations and moral considerations in order they may not harm the patient or the client. So we need judges who are on top of the task. So we talk about integrity building, education about the nature and extent of corruption, establishment of adequate accountability structures. It expresses the strict provision that any proposal for judicial training and accountability must be developed by or in consultation with the judges themselves in order to protect judicial independence. Judicial independence of paramount importance for people to trust the judicial procedures. There must be a high level of independence, and it must be protected at all times, so that we may not lose people saying, things can go to court, but the court is not going to do it in our favor, and so on. We must be able to sensitize the public also that this is what happens when it comes to cases like this. Remember, I mentioned in one of our programs that there are constitutional constraints and limitations before you even consider trying the person. The person must be properly arrested. If they are arrested, they must be properly arrested. You don't just arrest them. There is a way to arrest someone. They must be brought before the face of the judiciary within the prescribed times. They must be allowed time to speak to their lawyers and so forth and so on, and they must be allowed to apply for anything that they think will guarantee their human rights. And all these things the court needs to consider before even the case commences. That's why when we hear about the official things, the so-called, and they keep on saying the so-called, not imitating anybody. It's because I said we did not discover this case. Somebody else has discovered it for us. We have not discovered it ourselves. Nobody has really told us that this was discovered by a Namibian person or whatever. Somebody was able to discover it and give it a name for us. This is not how we should fight corruption. We must not wait for people from other countries to pinpoint corruption issues for us. We should be able to find these things by ourselves. And how do we find it? Only when we strengthen our institutions and protecting of the people, especially the whistleblowers we spoke last time. I mean, in some of our programs weeks ago. So there are constraints. We must always make sure that we are not violating constitutional rights of the people, even if they are in jail, because it may jeopardize even the trial process. Therefore, we must follow the Constitution. And that's why these things take forever. While in some other documents it said when there is a case of this nature, we must be able at least to speed up the process so that decision is made, rather than keeping people in jail for a very long time only to find out that the case will be thrown away. If the case is thrown away and you have kept people in jail for all of these years, you are going to pay to compensate for the lost time of these people who kept in jail, yet you are not able to prove beyond reasonable doubt that indeed there was a corruption committed against them. We must not just say we have a strong case, Prove the case. This is what has happened, and it must be convincing to the judges that it is not a cooked story to implicate somebody, but a real story. This is the constitutional problem. And that is why, quandary is not a problem really, but maybe a quandary or a dilemma. And therefore, we keep on saying that it's not an easy thing, but the judicial system must be believed to be doing the right things, must be seen to be doing the right things, and they must be seen to be independent and take independent decisions so that nobody is harmed in the process and nobody is let off the hook when this person has committed really a crime. So while the responsibility of the judiciary are stressed, for example, with regard to adherence of the code of conduct, ensuring transparency of legal proceedings, and disclosing assets and possible conflicts of interests, the judges and their families must also be afforded protection against corruption, especially from powerful and well-resourced interests. Can you see? We must not only talk about a code of conduct or transparency in the legal proceedings or disclosing assets, but we must also make sure the judges and their families are protected against corruption, because they can be corrupted too. Yeah, active and passive corruption. They can be corrupted by someone. Yeah, they can be corrupted by someone. And remember, political connotation, the undertone of politics within corruption and corrupt issues, is because we always want to pull each other down. And we may use any possible means to bring each other down using the guise of corruption. The judges must be the people to see this, and they themselves must also be protected, that they may not be seen to be committing corruption, or to be believed, to be known to be committing acts that are tantamount to corruption, especially when we are dealing with them. It's possible for us to bribe them. It's possible to bribe them unknowingly, inviting them for dinner, inviting them for events, and you befriend them to the point of them unable to dissociate themselves from you. That's why sometimes people who are corrupt, they tend to be good friends because they know how to keep each other's secret. And therefore, we don't need to bribe them. We don't need to befriend them with an intention to corrupt them or to make them look like they are corrupt and so on. And that's why I said some time earlier that even our politicians, they must exercise a serious caution when they form friendship. Yeah? When they pick their games, their players, political players for their games, they must exercise caution. Because some people who follow us, they follow us only because they want to hide something from you, whom they are following. So, and the only thing that they can do is to follow you so that you don't see what's happening behind the closed doors or something like that. And therefore, we must not befriend, we must not corrupt them, we must not find ways to corrupt our judges and their families and so on. But they must be able to declare, disclose their assets and possibly conflicts of interests. Such measures should be backed by wide-ranging court reforms to address corruption problems, including providing proper remuneration and working conditions for judges and other court personnel, improvement of court management structures, and statistical management of cases to identify patterns that may indicate bias or corruption. Public education will be key to raising awareness of the standards to be expected of judges and of the courts. What are we saying here? There must be reforms. There must be reforms. I wouldn't say what those reforms are, but those in the judicial system, those in the lawmaking system should be able to understand what law reform is, especially the code of conduct. The reform must include proper remuneration. We must remunerate our people in order to avoid corruption. Properly remunerated. And remember, the principle behind of making sure that not only judges, even politicians, when you are given a free transportation, you are given a free sort of housing, you are given this free, you are given that free, you are given that free, while you are in the employment of the state as a public office bearers. You are given all these things under the ideology that you may not crave for things you see outside of your professional or your political career or your judicial even career. You want to be a farmer, you want to be a fish quota holder, you want to be a shareholder here, you want to be there. You don't venture into businesses anymore. You get your money, you learn to save those monies in case you are removed or in case you are no longer a member of the ruling group. Therefore, you are no longer entitled to certain benefits and all that. So, in a way, you should not crave for bigger things. And now, if we don't pay them properly, if we don't improve their working conditions, we are exposing them to corrupt elements and to corruption itself. If you are not improving the court personnel, if you are not improving the court management structures, if you are not improving the statistical management of cases to identify patterns, that may indicate bars of corruption. We are breeding actually corruption, and therefore we must also involve public or civic education so that the nation may know what is expected of the judiciary when it comes to issues of corruption. So there we are, and I repeat as I come to the conclusion of our program. I would like to just give you a repeat or hints of what we are so far. We are talking about to assess the corruption and institutional capabilities against corruption institution. And now you are asking me if this is what we are doing in Namibia. Have we done so? I don't know. We must now answer that question as Namibians. Have we assessed the nature and the extent of corruption in Namibia? Have we assessed the institutional capacities and their responses to corruption? Have we built the specialized anti-corruption agencies very strong and independent, like now the Anti-Corruption Commission, the auditors and audit institutions, the ombudsman, and have we strengthened our judicial system? Have we? This is the question that we are talking about when we talk about this type of things. And then we will be coming to many other tools, because there are quite a number of them, but in abstract really, we are going up to tool number 44, and we are still here by tool number 6 yet. And we gave an overview of social prevention somehow from tool 22 to some other tools there, and we will refresh ourselves again. Are we doing the right thing when we have to establish our anti-corruption strategy? What is the anti-corruption strategy of Namibia? Do we know it? Is it part of the public? Do ordinary people somewhere know what is going on and whether they feel they own the program? This is the question we need to ask ourselves. And when we discuss amongst ourselves, we must tell us each other, where is the anti-corruption strategy? Where is it? Can we say all of us know where is this strategy? Are all offices, are all institutions, are all civil societies, are all public offices aware of this anti-corruption strategy and their role in it? Because every person must play a role in making sure that corruption is completely rooted out from Namibia. It must be completely removed from within the borders of Namibia. It must go somewhere. So we leave it there for today. And the question I have left with you, it seems we don't get quite a number of calls because people are either driving or something like that. I will discover the usage of our WhatsApp number, so that you can maybe send your audio or send a question or something like that, so that we can read it in the studio, because we would like to hear from you. Hearing from you makes us even better equipped. I thank those who have reached to us on a personal level, sharing some damning information as to what happens here, what have we been doing, and so on individual level. Some people have given us, really reached out to us and given us the information. May we also know what you are doing in terms of fighting corruption, so that at the end of the day, we can defeat this monster. All of us in Namibia are united in making sure that corruption is not the best. It is now for me to call it a day, and I will see you and you will see me next week. It is a Chila for Me program sponsored by Konrad Adenauer Foundation and brought to you by myself as a presenter, Lukas Katenda. It's a goodbye.
Root out corruption from Namibia. Corruption is harming the people of this country. When people ask you to do something you know you should not do for their benefit and offers you something in exchange, like a bribe, that is corruption. Corruption causes poverty. Corruption causes unfair and weak service delivery.